Christine Thornhill, and I'm a practicing family law attorney here in Polk County, Florida. And I've been practicing for almost 20 years, doing family law and criminal law. I'm here today to talk to you about how to divide your property and basically all of your stuff. Normally what I tell my clients when they come in for a meeting is to tell me about all of the stuff that you and your spouse have accumulated throughout your entire marriage. From the date of your marriage, not from the date that you started dating, not from the date that you moved in together, but from the date of your marriage until basically right about now. When the court goes to decide how they're going to split up the assets and the debts from both spouses in the marriage, the court looks at one of three dates. If the parties can come to an agreement, and whatever that agreement date is, the court will most likely go with. The second date is, when is the date of filing for divorce? When was the petition for dissolution of marriage filed? And the last final date is, sometimes it'll take a year, 2 years, 3 years, maybe more, to finally get to a final hearing. And if that's what happens, then the court will look at what is from the date that the parties married until the date of the final hearing. So what I tell my clients is, let's have a list out of all of your assets and all of your debts, because the court is basically going to pull them all together into a ball and split them in half. Equitable distribution means exactly that, 50-50. What's equitable? What's equal? So we take all of your assets, and that includes your income, your house, your cars, your boats, your jet skis, your storage units, your timeshares, your bank accounts, your retirements, your furniture in your house, your guns, your jewelry, your baseball card collection, whatever your assets are, we pull out and we put that on the table. And then we have to figure out what the value of that is, not how much you paid for it initially 20 years ago or 7 years ago, but how much is the value right now. And we do that for each of your assets. How much is in your retirement? How much equity does your house have? How much did you purchase the house for? What is the house value right now? What could we sell it for? How much is your mortgage? After we set up all of your assets and then how much the value is on that, then we look at the debts. What is the mortgage on the house? How much do you owe on the car? Old hospital bills are there, old telephone bills that weren't paid. Who do you owe money to? How much do you owe on your credit cards right now? And that includes any debt that is in the wife's name, how much debt is in the husband's name on either spouse. We need to know whether it's individually or how much it is also in any joint accounts. So once we have all of the assets and then all of the debts, and then we also assign a value to each of them, keeping in mind that we have to figure out what that value was accumulated during the marriage. So here's an example on retirement accounts. So if one spouse worked at Publix, that spouse worked there for 10 years before the marriage, but only 5 years during the marriage after the parties married, then only 5 years of that accumulated value in the retirement account is what gets split 50-50. The $10,000 that was accumulated prior to the marriage is non-marital. So when the court is looking at all of your assets and all of your debts, they're only looking at what marital assets and debts there are. Now this falls under Florida Statute 61.075. Now we go into court with a premise that everything should be split 50-50, which is very simple because we're finding out what the value of it is and dividing by 2. However, there are extenuating circumstances which would allow for one party to get more assets or less debt. So if one spouse went out and earned all of the money, got all of the retirement accounts, while the other spouse stayed home and took care of the children, made sure that the house was ready and dinner was ready and cleaned the house and ran errands and did all of that. There is a value also to that. So even though the retirement was only earned by one person, of course, first of all, it would be split 50-50, but perhaps one person should have more, one person should have less based on that factor. And that's an argument that would be made, not in an agreement, but the argument would be made to the court at the final hearing. Perhaps maybe one person worked for 25 years, the other person didn't work and didn't have the opportunity to earn any income, or any retirement. So because of that, we have to take into consideration that either way it needs to go. If one spouse went through medical school and internship and all of these things in order to get to specialties, in order to get to the career that spouse is in, while the other spouse did everything else, that's also a contribution that led to the spouse getting ahead as he or she is. So a couple of years ago, I had a case where the wife had a parent who had died and left her a lot of property in the parent's will. The wife was married and put all of that property that was willed by her parent into both names, which made that property marital. It was no longer an individual asset. It was no longer non-marital property. It was now marital. So the parties go to get divorced, and the only items, the only assets that the husband wanted was the properties that the wife had received from her parent, which was horrible. And so even though it was marital, we made an argument to the court that she should be awarded those properties. Not that they should be sold, but that she should get them. Because if the parties can't agree to a split of all assets and debts, and the court doesn't know which party should get which property or which asset or which debt, then what happens is all the property is sold, all of the assets are sold, and it's just an even 50-50 split. But we didn't want that. My client wanted the properties that her parent had willed to her. And so we made the argument that she should be getting these properties because of sentimental value, because they meant something to her, and they didn't mean anything to her spouse. And fortunately, the court agreed, and he got other assets and other properties elsewhere. So if one party has a non-marital property that's used for rental income, and the other spouse uses his or her money to retile it, put in a pool, fence it, to make these enhancements to the property, which makes the non-marital asset of more value, then the court will take that into consideration when determining which assets and debts both parties should get. When parties are divorcing, then you want to figure out, okay, who's going to have the marital home, or do we need to sell the marital home? And I always try to advise my clients that it's best to sell the marital home. It's got too many memories. It's best to just go ahead and say, let's just go ahead and sell the marital property. However, if you've got a spouse who's got small children, or maybe one that has a child that's 15 or 16 and wants to stay in the house for the end of his or her graduation for high school before they go off to college, and that spouse feels like it's very important, or that parent feels that it's very important to keep the child there, then we want to make that argument to the court that perhaps one spouse will stay in the house until the child graduates from high school, and then they sell it, pay off the mortgage, whatever equity is left over, then it's split between the parties. Well, the parties have been talking about a divorce, but they don't do anything. And 1 year goes by, and one spouse realizes that the other one is actually getting serious about wanting to file for divorce. He or she decides, you know what? I probably need to start looking out for myself and start selling off some property. Or maybe I need to go spend our savings account on a new Lamborghini. Or maybe I need to pull as much out of my retirement as I can, or put it in a separate account, thinking that's not going to be marital. Well, of course, it's still marital. And if you're intentionally getting rid of money, getting rid of assets, or accumulating debt, then the court's going to take that into consideration. So this is your catch-all, your opportunity to bring whatever else you need to the table in front of the judge. So again, that's Florida Statute 61.075 for equitable distribution of marital assets and debts.